Honor, before we get started, we will have an oral motion to amend the indictment to change.
All right, we'll get there.
Yes.
All right, court is calling 2024 CR 1048, State of Texas versus Jose Carmona. Could I have the parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Bernard Campton for Mr. Carmona.
And are you Mr. Carmona?
Yes, ma'am.
Counsel, have you received all of the discovery?
We have you.
Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Carmona, did you review the document entitled Application for Deferred or Community Supervision with your attorney?
Yes, Your Honor.
Did you sign it and understand it?
No.
Did you review the true bill of indictment with your attorney? Did you understand it? Do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor. In the indictment, the state amend 2006 CR 8079 to 2006 CR 8078 and further waives the habitual offender enhancement allegation.
All right, any objection to the waiver?
No, Your Honor.
Any objection to the amendment?
No, Your Honor.
All right, Mr. Carmona, do you understand that the changing of the cause number is a substantive change?
Yes, ma'am.
And do you understand that your attorney would have 10 days to prepare for trial?
Yes, ma'am.
And are you waiving those 10 days?
Yes, ma'am.
And do you wish to proceed?
Yes, ma'am.
All right, then the indictment will be amended as stated by the state. Any reason your deferred adjudication will revoke, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,000 fine. State, with regards to the application, are you opposed? Are you silent?
Silent.
All right, the state will remain silent on your application. This will run concurrent with 732-605. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
So the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State, any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
State will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. The case that he was pulled over for, where they said he had a warrant,
Yes.
what is happening with that case?
It got rejected or dismissed.
All right. So if you want, his reset date for PSI will be October 10th. Otherwise, if you want, I can accept from the state what his criminal history is, and then we can reset it for a sooner date, and you bring in whatever witnesses you would like to hear from.
October 10th would be fine with us, Your Honor.
Okay. So we're gonna come back on October 10th for sentencing. Does your client need a TAP evaluation?
I don't think so, Your Honor.
All right. Probation, that will be a PSI. Could I see a reset form, please? All right, once you sign the reset form, make sure you turn it back into the clerks. We will come back then on October 10th. I will make my decision based upon whatever evidence is presented to me. Do you have any questions?
No, Your Honor.
All right, thank you. Once you sign that, you're excused. All right, Enrique Hernandez. And can I have a reset form, please?
Just to provide to you, but I'll explain when we're on the record with the interpreter.
All right, who is the prosecutor on this case?
Andrew Harris, Your Honor.
All right, have you had a chance to review defense's motion?
No, Your Honor.
I was discussing with Mr. Escobar on this one earlier, but I'll give to Mr. Edelman as well.
All right, thank you. All right. So this case is going to be recalled for discovery to make sure that everyone has all of the documentation they need. And is your client a citizen or no?
He is not.
So are you going to take care of the immigration implications, or do you need an immigration attorney appointed through back?
I don't know if he needs one appointed. I did discuss with him that he would need one. We will not be taking care of it in our office. Um,
All right, so
I can
you're
issue-
hired, so
yes, ma'am.
you need to call Mac and see, even though you're hired, whether or not they're gonna do this, but I am not going to continue to reset because he needs to get an immigration attorney.
Understood.
All right. All right, so I'm gonna recall this for discovery, and this will give you a chance to talk to immigration people as well. We're gonna recall this back for October 7th.
Yes, ma'am.
All right, is there anything else?
I don't know if the state has had time to review the motion and if the court has
All
signed
right,
it.
once the state has reviewed it, you can always give it back to me, but I'm going to want it today.
Yes, ma'am.
And I'm going to give you a reset form. Once I give you the reset form, please sign it. Take your copy and give the remainder to the clerks. And then you're excused.
Thank you, Judge. And if I may reapproach. Mr. Edmonds, that he's no opposition to the motion.
And states you're in agreement to 1 through 33.
Yes, Your Honor.
All right, then, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. All right, thank you.
you,
Good
Judge.
seeing you. Have a good one.
You too, Judge.
All right, and Mr. Young, what is your client's name?
Yesenia Cardenas, Your Honor.
All right. Court is calling 2024 CR 2331, State of Texas versus Yesenia Cardenas. Can I have parties announced for the record for the state
Andrew Harris, Salem.
defense?
John Young.
And are you Ms. Cardenas?
Yes, ma'am.
All right, we're here. The defense has filed a motion to set bond. The defendant was remanded without bond because she was not abiding by conditions with pretrial services. There was a 7th violation report issued. And the court set this for March 13th, 2024, and the defendant was a no-show and did not appear by 10 a.m. So is there an agreed?
Agreed recommendation, yes, Your Honor.
All right, and
We had a
what's,
previously $2,000 bond. That obviously is, she's remanded without bond now. We've agreed to a $5,000 recommendation to the court.
all right, and state, with regards to this recommendation, you are aware that she has not been showing for her pretrial services officer, and it was a 7th violation?
Yes, Your Honor. State would request partial house GPS.
I request tracking, Your Honor, since this is not something that we're trying to prevent her from interfering with somebody. We'd like her to visit with somebody periodically. That would let us know where she is
Visit with, who would she like to visit with?
with pretrial services, Your Honor.
Well, I don't know if she's gonna be under the behest of pretrial services anymore, but
Okay.
she would be allowed to visit with pretrial services. So your agreed bond is,
$5,000, Your Honor. And if you do impose GPS, we would ask that A, you waive the fee, and B, that it be tracking only.
all right, the court is gonna follow your agreed bond. There's a $5,000 bond. There's gonna be full GPS, waived fees. There is going to be random UAs through pretrial services, waive fees. And GPS is until further notice. Do I have a reset form, please? Defense, have you received all of the discovery in this case?
Have not, Your Honor,
All right, what is outstanding?
everything.
Oh, state, have you not uploaded anything?
I don't know whether they've uploaded it or not, Your Honor. I don't have any discovery on this case. What I have in my file, which is fairly voluminous, was a previous case that's been dismissed.
Okay. All right, this is gonna come back on September 16th for discovery.
Thank you,
State, please make sure everything is uploaded. All right, once you all sign the reset form and return a copy to the clerk, you're excused.
Your Honor, you did say that you wanted full house arrest on
Yes.
this.
If
If
she
she-
obtains employment, you can come back.
Thank you, Your
You're
Honor.
welcome. Who's here on Crystal Cherry? All right, what are we here for?
Well, this is an MTR, Your Honor. I've conferred with everyone. Probation is scheduled a tap for Friday in jail. And they'd like to do a mental health evaluation on 9/9. And so I'm asking the case be recalled after 9/9, so we can have that information.
All right, she's supposed to be on the mental impairment caseload. Is there a reason why that's not already done?
I think it's probably because after she had an MTR,
Mhm.
I think in February, around
January.
January, and I
She
think.
had an MTR for a violation of condition number 4.
Right,
And I ordered that she be placed on the mental impairment caseload. So here we are in,
right. So I think that
August.
those things weren't done after they were ordered. And so.
all right,
because-
so probation. Can you tell me? All right, she's gonna look into that. Let's see what happened.
Okay.
So just give us a moment. Yes,
So I don't see any action on her being referred to MIC. I do see she had previously had her mental health evaluation and it did not recommend MIC.
okay.
So they had referred her to Access, or that was a recommendation. But I don't see that there was any type of action. I know there was like some issues with her coming in and then she missed her outpatient appointment. And I'm assuming after that was when the MTR happened. So I don't see that they made any
Come down.
referrals to the Access program. I can reach out to our MIC manager to see if he's familiar with that referral process looks like.
Okay.
I do see that the officer documented that she would continue with it, but I don't see anything that she was actively in that program because
Oh.
Access is kind of like the overflow of MIC.
All right, this is what we're gonna do. We're gonna come back on September 12th. And this case is going on September 12th. All right,
And I'll get confirmation on all that, Judge.
all right, thank you.
Yes.
Yvette Martinez. Court is calling 2023 CR 1876, State of Texas versus Yvette Estrella Martinez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Excuse me, Glenn Payne for the defense.
And are you Miss Martinez?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Yvette Estrella Martinez who was placed on community supervision in 2023 CR 1876 for the offense of intoxication assault with a vehicle, serious bodily injury on August 10th, 2023 for a term of 10 years? Is that you?
Yes.
All right, I don't have trial court certification. All right, state.
Violating condition number 14M on or about the 13th day of June 2024 in Bexar County, Texas. The defendant Yvette Estrella Martinez, defendant there, failed to register for or attend a certified DWI intervention program with the approved agency in violation of condition number 14M.
How do you plead to that? True or not true?
I plead true to that, Your Honor.
So Your Honor, state waives all the violations.
Any objection?
No objection.
All right, did you understand by pleading true to violation of condition 14M? Court could find it true, grant the motion, and sentence you to 10 years in the prison
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation 14M?
Yes, Your
Court will find 14M true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is for the defendant to obtain scram instead of the PAM device, and then zero tolerance for alcohol consumption.
All right, why are we doing scram instead of the PAM device?
Judge, because there's been a lot of missed tests on the PAM device, and so both state defense figured that the scram device would keep better track of any possible alcohol consumption.
And if I may, Your Honor, there've been no positive UAs for, or no test for alcohol. It's been an issue with the actual machine, her using the machine, picking it up and getting the proper testing. She's done many proper tests throughout the month, but she can explain it to you. It's kind of
All right, how does that
convoluted.
explain skip tests? That's what I don't understand.
She picks the machine up and resets it and then puts it down, and it's saying that it was blanking out previous tests, but she was taking numerous tests. She even had an issue this Friday, late Friday, when I was picking a jury where the charging cord, the individual said that the charging cord was not working proper. That's why probation has said scram, so there should be absolutely no issues with any type of her personally doing anything.
This is what I'm gonna do. I'm finding 14M true. I'm not gonna make a ruling. I want that person somebody from this PAM monitoring device to explain to the court about these skip tests. And then the court will make a decision on what I'm going to do with the motion.
Okay.
All right,
So
do I
not
have a
the,
reset form, please?
so Judge, not the scram, but the portable.
Whichever one that she is saying there have been issues with it coming up as skipped and she really didn't skip. So how much time do y'all need to have that person come in?
Maybe we could do just to make sure that we have the right person, Judge.
All right. You want to set it for September 12th? Is that enough time?
That should be enough time, Judge.
All right, we're going to come back on September 12th.
Like the company that her device is from
Yes.
is Lifesaver portable alcohol monitoring. And I'll give state the contact information for that.
Thank you. Any objection to that person appearing by Zoom, or defense, you want them in person?
No, just no objection. I would also like to get the information, so maybe I could talk to them.
Okay, so you're okay with them appearing by Zoom?
Yes, ma'am.
All right, if you'll let them know, state that they can appear by Zoom.
Yes, ma'am.
Once you sign the reset form, you're excused.
You're doing it all today. Thank you.
The state,
I thought we had.
who is the prosecutor for state on Eric Kelly? Eric Kelly?
Not know, Your Honor.
All right, Mr. Behrens, just give us a moment. If you'll talk with Mr. Edelman. Just have a seat, we'll get with you. All right, could I have a prosecutor for Dennis Paul Pellegrini, please? All right, on this case, it's on page 1. And I know of late, sometimes when the cases are indicted, something's been happening weird with Odyssey. So what I'm going to do, Norma, if you can reach out to Miss Gail Calderalo and state if you have no objections, I'm just going to recall it.
No objections.
All right, so Miss Ferguson, let's recall this for tomorrow and have Gail Colorado get in touch with her client and get in touch with the bondsman. All right. This here on Pettis, Dorothy Pettis. Ms. Pettis, if you come forward. Probation, this is an application. Could I have a prosecutor? Court is calling 2023 CR 0941, State of Texas versus Dorothy Pettis. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Patrick Lamas.
And are you Ms. Pettis?
Yes,
Counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Ms. Pettis, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
yes,
And did you sign it?
yes,
Did you review the true bill of indictment with your attorney?
yes,
Did you understand it?
yes,
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you understand you're charged with possession of a
Yes,
controlled substance, penalty group 1 less than 1 gram?
yes,
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
yes, yes,
According to the plea, there's a $1,500 fine. State recommends deferred adjudication and there's to be restitution to SAPD for drug testing. Did you understand that to be the
Yes.
plea?
I do.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State, any evidence?
50 containing Exhibit 1 and attachments, Your Honor.
We have no objections, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes,
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
yes,
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just hope that you follow the plea bargain agreement. As for the fine, I know there's a $1,500 fine. My client doesn't have much income. She's planning on living at Haven for Hope after she's released from jail. So we'd ask that the court probate the fine, or part of the fine or the fine entirely.
All right. Do you have any children?
yes, I have 5.
And what are their ages?
One's 8, 19, my youngest, just turned a year,
Okay, 19, 1 year, what else?
and then 14.
Mhm.
And then 9, and then my son, he's about ready to be 4.
Okay. And who keeps them?
Uh, my dad in Washington State, and then CPS.
Okay. So which children or what ages of the children does your father in Washington have?
The 19, the 14, and then the 9.
All right. Oh, and just out of curiosity for me, is he planning on taking the 1 and 4-year-old or no?
No,
So what is going to happen with the 1 and 4?
the 1 and 4-year-old, my cousin Corley's gonna take.
Who?
My cousin Corley's.
All right. Have your parental rights been terminated to the 1 and 4-year-old?
Not yet.
All right. Who's your CPS attorney?
I don't remember his name quite yet. I'll be getting it once I get out.
Well, how long has the CPS case been open?
It's been open for like 6 months, 8 months now.
All right. You have a year to get your act together.
Mhm.
You should know the name of your attorney because that's very important because it's involving your children.
Yes.
So where is your support system? Where is your mom, your other
My
family?
mom, she's in Missouri. She's not out of medical conditions. And then my dad, same thing.
All right.
So,
And who is Dwayne Garcia?
Dwayne Garcia, he's one of my favorite street uncles.
Street uncle.
Yeah,
What does that mean?
I've known him for years.
No, but I mean, if you've known him for years, why is he just not a friend? What does that mean? He's a street uncle.
My family hasn't met him yet. From their medical condition, it's been hard for them to meet him.
No, but I mean, why is he a street uncle? That's what I don't understand.
He was taking care of me while I was homeless.
How was he taking care of you?
When I would ask for help, he'll give me the help,
Like what type of help?
food, anything.
But I mean, you both were caught with drugs. So he's probably not a good person for you to be around.
No,
Was there anything else going on between you? What
no,
was he expecting in return?
nothing.
Because what I've discovered, normally in the situation that you're in, yes, you may end up meeting great people who are just there to help you. But from looking at what I'm reading in the police report, he's just not helping you out of the kindness of his heart.
No.
So he's not, right?
Mhm.
Is that a yes, he is not helping you out of the kindness of his heart?
No.
All right. So you're gonna have to make a decision on how you want your life to be.
Hmm.
And either you're gonna stop having children and just do whatever you want to do. But if you're gonna continue to have children, then you've got to get your life together, because otherwise your children are being raised by people. You just, here you go.
Yeah.
And now the 1 and 4-year-old, they're not even with their siblings. And how do they feel? They've been left behind and somebody else has them.
Yeah. True.
All right, this is what the court is going to do. I'm going to recall the warrant, sentence you to 3 years deferred adjudication. There's to be a TAP evaluation in custody. Follow recommendations. I'm going to want a referral to Esperanza Court. And that's a program that you really should be in. You understand?
Yes.
And there's to be no contact with your street uncle. And that's Dwayne Garcia. And I'm not going to interfere with your CPS case, but I'm looking at your ancestry and it says American Indian or Native Alaskan.
Hmm.
You need to let your attorney know that,
Okay.
because that's very important on CPS side.
Okay.
There's going to be CPS compliance. 150 hours community service restitution. How far did you go in school?
11.
All right. I'm going to waive 100 hours of those for parenting classes that she completes. The other 50 hours will be waived once she obtains GED or is in some type of trade school. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. All right. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
All right, we can go off the record. You're going to have to make some decisions quick, fast, in a hurry.
Okay.
And that's going to have to be whether you want to be in your children's life or not. If you don't, just cut them loose, because it's heartbreaking for children when they get their hopes built up that their parent is going to end up being a good parent.
Mhm.
And everything is going fine in CPS. And I can tell you this because I represented parents in CPS before. Everything is going fine. Visitation is going fine. Next thing you know, they end up with their street uncle, or they end up with some guy and bring some random guy in their life. And then bam, children don't have them anymore. That's trauma for a child. You understand?
Yes, I do.
All right. So in this court, if you get transferred to Esperanza Court, that judge will be over conditions of probation. It's a very good program and it's something that you need. You understand?
Yes, I do.
All right. If you feel as though they're not addressing issues, you can always come back here and see me.
Okay.
Okay. And counsel, I know it's not your job, but she doesn't know who her CPS attorney is. If you call over to CPS court and take her name, give them her name or the name of her children, they'll be able to tell you who her CPS attorney is.
I'm happy to do it, Your Honor.
All right. Thank you so much.
Thank you.
Thank you.
Have a good day.
Thank you. You too. Eric Kelly. Court is calling night mag number 738-931, State of Texas versus Eric Kelly. Can I have parties announced for the record for the state,
Daniel Escobar from the state of Texas.
for the defense? And are you Mr. Kelly?
Yes, ma'am.
All right, defense is asking that his conditions of GPS be modified. Any objections to the defense's motion?
Judge, the state would ask you remain on partial, but we understand that it's been good amount of time since he was let out on bail. The state would also understand if he modified it to tracking only.
All right, so with regards to tracking only, is there any no contact orders?
My understanding is yes, Judge, but I need to look into any bond condition.
So what has has been on previously?
Judge, he's been on GPS since he released November 28th last year.
All right, was that full GPS? All right, so what is he on currently with regards to?
Partial. We had a hearing on March 14th in front of Judge Moore, and he monitored it to partial, modified it to partial. We had asked for tracking then, but he said, let's see how he does for a while. It's been, I think, 60 days or more. There's been no violations.
All right, state, any issues with GPS?
Judge, again, the state would ask for tracking.
All right, then the court is going to grant tracking only, and whatever no contact orders are in place, those are to remain in place. Do you understand? If you violate this, what's going to end up happening is a warrant could be issued for your arrest. You may end up going to jail, or you may end up back on full GPS. Do you understand? Any questions?
Amen.
All right,
Judge, I do have a
Yes.
couple things for the court to know, consider. One, since he's on tracking now, I assume that it'd be okay for him. He had a neighbor who wanted him to help with a 2-week project.
and he's just on tracking. The only thing he needs to do is whatever the no contact order is, which I'm assuming, and I don't have access to it.
I haven't pulled up here, Judge.
All right, who is the,
Ryan, and then how they wrote it in was DEKRONE.
wait, Ryan, RYAN,
Yes, ma'am.
last name?
DEKRONE.
Okay,
And then not to go near an address, it's
just 1 second.
Sorry, Judge.
All right, is there anything else?
Nothing.
All right, thank you.
For full transparency, then he will be attending a cousin's funeral in Tyler on Wednesday.
Oh, I'm sorry to hear that.
All right, thank you, ma'am.
You're welcome.
Thank you.
Take up the jury. Anyone else who's ready? Yes,
Under approaching Shannon Anderson.
all right, yes. Shannon Anderson, come down. Yes,
Your Honor, I've conferred with the state. I just received a CD with the phone dump.
okay.
iPhone, but I do need time to review that for my client.
All right, Ms. Fergus, can I have a 30-day reset for discovery on Shannon Anderson, please? All right, September 19th, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome. Calling 2024 CR 007-175, State of Texas versus Paul Padilla Jr. Can I have parties announced for the record for the state
Andrew Harris Sadelman.
defense?
Cornelius Cox.
And are you Mr. Padilla?
Yes, Your Honor.
Counsel, have you received all of the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Padilla, did you review the document entitled True Bill of Indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Like to make an oral motion to amend the indictment to change cocaine to methamphetamine and to waive the second enhancement paragraph and proceed as a repeater rather than a habitual.
Any objection?
No objection.
All right. Mr. Padilla, do you understand that the state is asking that the name of the drug be changed to meth as opposed, well, methamphetamine as opposed to cocaine?
Yes, Your Honor.
Do you understand that's a substantive change to the indictment?
Yes, Your Honor.
Do you understand your attorney would have 10 days to prepare for trial with that change?
Yes, Your Honor.
And do you wish to continue with this plea?
Yes, Your Honor.
All right. Then the court will grant the state's motion without objection from the defense. Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Normally, that's a second-degree felony. However, if the state is able to prove up paragraph 1 of the enhancement paragraph, then your range of punishment will be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, ma'am. Yes, ma'am.
According to the plea, punishment is to be assessed at 10 years in the prison. You'd agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. There are no applications. The state is taking in consideration NIGHTMAG number 756633, 756637. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, sir.
Indictment as presented, how do you plead? Guilty, not guilty, or no contest?
No contest.
To the enhancement paragraph, how do you plead? True or not true?
True.
All right, and for the record, that's to paragraph 1 of the enhancement. State, do you have any evidence to support the defendant's plea?
Contained in Exhibit 1 attachments, Your Honor.
Okay.
All right, state, you may be excused. Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and lab reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty, and the court will find paragraph 1 in the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are we proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
We just asked the court to be considering and to accept the plea agreement.
Then the court will follow your agreement. The court will sentence you to 10 years in the prison, give you credit for any time served, taking consideration 756633, 756637. Is there anything else with regard to sentencing?
No, Your Honor.
All right, we can go off the record. Here's the thing. Your counsel will tell you, I understand that what was used to enhance you was a burglary of a vehicle. Now burglaries of vehicles are not felonies. I once had a client on parole, was doing a life sentence on a burglary of a vehicle. So here's the thing. How old are you?
I turned 50 this past Wednesday.
Turned 50?
Yes, ma'am.
All right, so I can say this because I'm in the same age bracket. We're on the downslide. Like I always tell people I'm in the winter of my life.
Yes, ma'am.
So you got to decide, do you want to spend the rest of your life in the prison or on lockdown? If you don't, you're going to have to make some changes. Otherwise, when you come out, you're going to pick up more cases. You understand?
Yes, ma'am. I just lost my father on Father's Day. I do understand.
All right, so you got to do better.
Yes, ma'am.
Now, go forth. If you don't want to do it for yourself, do it to make your father proud of you.
I will.
All right, good luck to you.
Thank you, miss. Thank
You're
you very
welcome.
much.
Have a good one.
God bless you.
Oh, thank you. God bless you too. Roland Sanchez. All right, after this, we're going to start on the trial. All right, what is happening with Mr. Sanchez?
Since we just had it bench warranted back last week or so from TDC.
Mhm.
It's an unrelated case. And we just got an offer this morning from Mr. Daniel over here.
Okay,
So we are actively, I have Ms. Kern appointed. She's downloading Discovery and we'll be reviewing that as soon as we can.
all right, Ms. Ferguson. Let's recall this in 30 days for discovery. All right, we'll come back on September 19th and I'll note that the state has already tendered an offer.
Yes, sir.
All right, any questions?
No, ma'am.
All right, we'll bring you back on September 19th.